All right, next we're going to be looking at some will construction and interpretation issues. The will construction issues that we're going to be addressing primarily arise as a result of various changes that occur between the time that the will is executed and the time that the will speaks. But first, before we get into lapse and anti-lapse, which addresses beneficiaries dying after the will is executed but before the will speaks, we're going to take a quick review at what constitutes the will, thinking about a codicil as an amendment, same formalities required. Incorporation by reference takes something that is completely outside the formalities, outside the four corners of the will, and makes it part of the will by satisfying three requirements: intent, existence, and identification, keeping in mind that the UPC has a special rule for tangible personal property. As long as that writing is signed by the testator, it does not have to be in existence at the time of the will, but keeping in mind it only deals with stuff, tangible personal property, not real estate, not money. And finally is the idea of facts of independent significance. There are going to be changes that occur between the time that the will is signed and it becomes effective. And the question of facts of independent significance is, are those changing events occurring for independent reasons, even if they do affect the will? And if you could argue that they are independent, they are of independent significance, then the will stand. All right. Will construction deals with the testator's intent, looking at the four corners of the will. We have some general rules of construction that you might not have been exposed to prior to wills. What kind of extrinsic evidence can we look at? What is extrinsic evidence? Basically, something outside the will that sheds light on what the words of the testator mean. In terms of a drafting suggestion, as you think about the estate planning project that's coming, contingencies, you always want to clarify with your client whether or not they prefer the beneficiary to survive, thus use language to avoid the anti-lapse statute that we are going to be talking about today. If there are multiple beneficiaries, do you want to use classes? If there are co-owners, do they own it jointly with the right of survivorship or as tenants in common, or between married persons as tenants by the entirety? Those are things that you need to clarify with your client and try not to rely heavily on the default rules. All right, what happens when the name taker does not survive the testator? That is what we are talking about today, primarily. Under common law, there is this concept known as lapse. So the idea is that no testator would want a beneficiary who is not able to use and enjoy the property to have it. However, every state has adopted what's called an anti-lapse statute, thus avoid common law lapse. And Maryland has a very odd statute that forces the deceased beneficiary share through the predeceasing beneficiary's estate, which means if the predeceasing beneficiary had a will, it would go to the will beneficiaries, and if not, it would go to the predeceasing beneficiary's heirs under intestacy. The UPC and a majority of the jurisdictions, however, follow a two-part test. They look at the relationship between the predeceasing beneficiary and the testator, and if it's the type of relationship to which the anti-lapse statute applies, that's part one. And then that person must have surviving issue, in which case it would go to those issue as opposed to going through that predeceasing beneficiary's estate. So this is one area where Maryland is drastically different from the Uniform Probate Code. All right, so lapse, you execute a will, you name a beneficiary, and that beneficiary dies prior to when the will becomes effective. What happens? Well, think about it. I have a general bequest of $100,000 to my daughter Alice, and the residual goes to my son Bobby. Alice predeceases testator. What do we do with that 100,000? Under common law lapse, the 100,000 would become part of the residuary and going to Bobby. Under Maryland, the $100,000 would go through Alice's estate. And under the UPC, it would be a two-part test saying, is Alice the type of relationship that we want the anti-lapse statute to apply? In this case, a daughter, yes. And secondly, does Alice have descendants? What if Alice doesn't have descendants? Well, then we're back to common law lapse because the UPC has a two-part test, not just a one-part. It's not just the relationship. It's the relationship plus issue or descendants. So these are the things that you need to look at. The Maryland has a different statute than the UPC. Take a look at the Raywinkle case. Look at the estate plan. Did the testator draft around anti-lapse? Was that language sufficient? One party wants anti-lapse statute to apply. The other party wants the language to be sufficient to get us around anti-lapse. That's what the estate of Raywinkle is looking at. Equally, Ehrlich's son is the same situation. We're looking at whether or not the language was sufficient to get us around the anti-lapse statute. It may have been sufficient to get us around the anti-lapse statute if either Melvin or Rodin had survived, but that wasn't the case. So what then? So take a look at the estate plan, look at the language to see if it's enough to get us around the anti-lapse statute. Pay close attention on the language. Sometimes these anti-lapse statutes are called default because it says in Maryland's 4-403, unless a contrary intent is expressly indicated in the will, then this anti-lapse statute applies. The Maryland case is exactly that. This went all the way up to the Supreme Court of Maryland, looking at the testator's two provisions, particularly as it related to son Dennis, and whether or not there was enough language in the will for to draft around anti-lapse. The lower courts thought so. The Supreme Court says no. And as a result, it's going through Dennis's estate. So that was not language to draft around anti-lapse. Even share and share alike, which is typically closer to a per capita division as opposed to a per stirpes division, wasn't enough in that particular case. There's also a problem, is titling property as joint tenants with the right of survivorship. So if the will had said $100,000 to Alice and Susie as joint tenants with the right of survivorship and Alice predeceases, is that enough to avoid anti-lapse, or would Alice's share go through anti-lapse through Alice's estate? Interestingly, we have talked about several situations, disclaimer and slayer, where people may not have truly predeceased, but we treat them as predeceased. So if we have a disclaimer by an individual, they don't want the property, they say no to the inheritance, or we have a slayer, a bad act, intentional killing of the decedent. Under the UPC, we can apply the anti-lapse statute. We can look to the will. Was their language sufficient to draft us around anti-lapse? If the will is silent as to survivorship, the default is the two-part test. Because under the UPC, if someone isn't really dead, we can pretend that they have predeceased because we have a way of establishing the issue, the relationship, and whether or not they have issue. Under Maryland, that doesn't work, because the way the Maryland anti-lapse statute is that it forces it through the predeceasing beneficiary's estate. We would have to know who the heirs are, who have to survive in order to inherit, and a will can always be changed. So there's no way of pretending predeceasing beneficiaries exist under Maryland, and therefore disclaimer and slayers do not go to the anti-lapse statute in Maryland. All right, thanks. See you soon.